Okay. Uh, Welcome to this special session of Matchpoint Talk, where we delve into some of the most critical and intriguing topics in sports law. Today, we are privileged to host a discussion on a subject at the core of the sport dispute resolutions: evidence in sports disputes, common issues, and best practices before the case. It's the moment to present our kind speaker, Ariana Mendoza.
Good night, good afternoon to the ones that are here from this side of the world, from Latin America. I think that there's a lot of people from Brazil and also from people from Europe. Good night to everyone there. As Mario said, well, not as Mario said, I don't think that I am that experienced. All the experience that I have, it's basically what I learned from people that I really admire, like really admire a lot. So it's just knowledge that comes from one generation to another one, from my bosses to my not like people from the middle to me. So I'm here just to share with you guys what I learned and what I currently do every single day of my life, because there's not any single day that I don't receive an email from CAS. So every day I work with this. Probably not every day I write a submission, a big one, or a claim or an appeal, but every day I have to deal with these situations, with these best practices in sports arbitration in front of CAS. So I don't know if you want to start, if you have any question before me to start with the presentation, or do you want me to go through it right now? So probably I will start. We are not that many, so I think that's ideal because we can do this really dynamic. This can be more like a conversation. I will really appreciate if you can take down the pressure on my shoulders and we do this like a really nice talk between friends. Like that would be amazing. But if not, well, good. I will start with my speech. So the nice title that Sports Hub suggested to me, it's common issues and best practices before the CAS. I will say probably very, very common issues, not that common issues, but not that best practices in sports law, because to be honest, every single day we face with different situations that were not faced before. So they are quite new. Every single day probably is not a common practice that we can now say that it's customary already settled. So every day is like a challenge. Every day is something new. Sports law is very dynamic. We have a very dynamic field that is always developed in a current development, because actually sports law basically not just have the regulations, but it has the decisions of CAS and FIFA. So every day we will have a different decision, and probably every single day we will have a different common practice, common issues and best practices to start studying and start putting into practice. So I will start the presentation from here. This should be good. Okay, I'm here. Ideal. Okay, that's the nice title that Sports Hub suggested for us: common issues and best practices before the CAS. Evidence in sports disputes. So our legal framework, it's basically Swiss law. I don't know if everyone here is aware that when we submit an appeal or a statement of claim before request for arbitration before the CAS, we are also acknowledging that Swiss law applied to our case, to the procedure, basically. So Chapter 12 of the PILA applies. What's Chapter 12? It's the international arbitration from the Swiss Private International Law Act. This is a very, 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 I will say, a specific field. It's very complicated because we're talking about Swiss law. We're talking about a national law that it's very complicated. It's not like sports law that is very dynamic, very FIFA, very I will say, sporty. It's more like, it's more real. It's more professional. Not professional, but it's more serious. I will say that's the way that I see it. And we have two articles that are important for what it's evidence about. First is 184. The arbitral tribunal takes the evidence itself, and 182 that basically says that the parties may determine the arbitral procedure either themselves or by reference to arbitration rules. They may also make the procedure subject to a procedural law of their choice. What they are basically saying is that every evidentiary issue will go accordingly to the CAS code. That's the arbitration rules, because when we decide to go to the CAS, we are not just deciding to go to the CAS. We are deciding that our procedure, the arbitration procedure, will be ruled by the CAS code as an arbitration rule that will regulate the whole procedure from the beginning to the end. But of course, the CAS code is not infinitive. It's like, it has, I don't know how many articles, but it's very simple. So if in case of silence, if the CAS code do not address a point that we must discuss or we must put in practice, probably regarding the evidence, we don't know how to do something. I don't know what can come to my mind at this point. About translation, probably. About translation. If a translation must be formal or can be read and make. Of course, the CAS code doesn't state that my translation of this document must be formal or must follow certain formality. So I can go in that point, I can go to procedural rules decided by the panel. That can be procedural rules decided by procedural rules of a national law to decide this point where the CAS code is in silence. But usually this doesn't apply because the procedures before the CAS go very simple in terms of evidence. So probably everything will be resolved with using the CAS code, using PILA when applicable, and using the customary practice at CAS. That is, at my point of view, it's very well developed, and from this point onwards. So our legal framework beside PILA that goes on the top, it's of course the Code of Sports-Related Arbitration, the CAS code, in a few words, in a simplified way. I believe that this is quite a lot of text that doesn't say that much, but what I wanted to bring you guys here is the relevant types of evidence that are admitted before the Court of Arbitration for Sport, before the CAS. First, we have written evidence. That's like a document. We can submit a contract. We can submit a regulations from a federation. We can submit a power of attorney as a proof, can be. We can submit any single written evidence as a proof. In addition, as probably, I don't know if you are aware, but at FIFA, in procedures before FIFA Football Tribunal, by instance, you can just submit written evidence, but not at CAS. At CAS, you can also offer witnesses and experts that they can bring their testimony as a witness of a fact or as an expert about the area of expertise. So here we see a difference between what happens in FIFA and what happens at CAS. FIFA doesn't allow you to do much more to prove your facts or your case. You can just submit documents. But before the CAS, you can also submit witnesses and experts. And I think that this is really important because usually a writing document and a writing evidence doesn't say that much what I wanted to share. Like a document doesn't bring you context. A written document doesn't share with you any single detail about what happened before the subscription of that document, before the issuance of that document, or after the issuance of that document. A written evidence is just a document that needs to be contextualized to prove a fact. So I believe that witnesses and experts, they really help with this. So to have a really strong point fully proven before the panel, you just not need to have your document, but also you need to support it with a witness statement, with a witness testimony, or an expert, if that's the case. In addition to that, you can also request an evidentiary measure. What is this? It's like usually you don't have everything in your hand. You have your case, you have your facts, you have the law, but you don't have everything to support what you are saying. You don't have anything to support or to prove what you are requesting. Usually, probably you don't have it, but you know that it does exist, but you know that the other party has it. So you can go to the cast, to the other party, to the cast, to the panel, and say, look, I know that the player, probably, or the agent, has this document on his power, but I think this is important for our case because this will prove this, this, and this. So please cast, please panel, request the other party to submit this document that they have in their power as a proof. And of course, the panel has really broad powers to request the other party to present that document as a proof, to prove not their case, not their facts, not the facts of the other party, to prove your facts. So this is quite cool because I think that for us, not in common law, in civil law, in that kind of approach to the procedures, we don't have this discovery process that they have in common law. In common law, it's quite common that you usually approach to cases not having everything in your power to prove your facts, but you can also request to the other party to show, to present documents or proof that they have that will help you. But for us, that for this side of the world, for part of Europe, we are not quite familiar with these kind of procedures, but CAS already acknowledged this tool that I find really interesting for us to use, because in contractual disputes, it's quite common that you don't have everything in your power. So you can ask the panel to order the other party to submit something that is in your favor, but you have to be sure that they have it. You cannot just try to assume that the other party has it. You need to really substantiate your request and prove that you are aware that the other party has it in his power, on their power. So until now, we have, as a relevant type of evidence, we have written evidence, witnesses, experts, and other evidentiary measures that are the ones that you can request the panel to bring. It's not that different to a normal procedure before ordinary courts until now. I think this is what I was saying before, like evidentiary proceedings ordered by the panel. So you can request the panel to order the other party to produce documents in its custody or under its control. The party seeking such production shall demonstrate that such documents are likely to exist and to be relevant. If it deems appropriate to supplement the presentation of the parties, the panel may at any time order the production of any additional documents or the examination of witnesses, appoint and hear experts, and proceed with any other procedural step. So it's not just the other party that may ask the panel to order the other party to produce documents in its custody. Also, the panel may understand that you didn't prove your case quite well, and they have the power, they have the faculties to request the parties to present further proof. But of course, you can. I never saw that a party was other party questioning this point. Maybe if you are not if you do not completely agree with this decision from the panel, maybe you can raise that you are not, do you believe that the other party did prove his point, or did not prove his point? But maybe you can raise this to the panel. I never saw it. Probably I will do it if I am in a case and the panel says to their party, please submit this other document that we think that it's quite useful for the case. Probably I will say, panel, I don't believe this is pertinent. I don't think this is relevant. Please dismiss this decision. Probably, I don't know if we will work. Probably not. I'm just overthinking here, but that's interesting as well to understand how it works. Now, the burden of proof. This is a step above all the other topics. I think this is quite more difficult to understand. For me, I think that to understand the burden of proof at first instance is quite easy as a general principle. If you understand the general principle, I think we are fine. But this general principle has exceptions. So with deception come all the troubles and all the particularities of the case. So the general principle is that the party must provide sufficient, clear, and convincing evidence to support their claims. So which party bears the risk if a certain fact cannot be proven? This means that if I am saying a fact, of course I have to prove it. I think that's basic lawyer knowledge, but I think this is where the burden of proof starts in sports law. You have to prove your facts. But this is also supported by Swiss law. The Swiss Civil Code actually address that unless the law provides otherwise, that's important, the burden of proving the existence of an alleged fact shall rest on the person who derives rights from that fact. This is the main rule. But this is important to understand that unless the law provides otherwise. In sports law, it's unless the regulations provide otherwise. Because we will see that FIFA regulations, doping regulations coming from WADA or for other international organizations, they actually state and establish some exceptions to this general rule. Why? Because usually the international organizations, they are not equals to the parties involved in the procedure. We know that in sports law there is not like a line. They are not in the same level. We always have the federation organization above the other parties, and of course they have more powers. They are more entitled to do stuff. They have really all the faculties. They have powers. They have their bylaws, and actually they are above. They are like more than the members. So makes sense that at this point, sport law creates an exception to the general rule. So some exceptions and particularities within sports law to the burden of proof. We know that the general principle is that if you raise a fact, you must prove that fact. But, for instance, the burden of proof regarding disciplinary infringement rests on FIFA. So if I commit a disciplinary infraction in FIFA, if I am an agent, if I am a club, if I am a coach, if I am even a FIFA member or a FIFA delegate, FIFA must prove this infraction. I don't have to prove it. FIFA must prove this infraction, and what I have to do is to prove that I didn't commit it. Or if I commit it, I have to prove why FIFA cannot sanction me in the way that they wanted me, that they want to. Why do I deserve a lower sanction? Why do I deserve to not be sanctioned at all? So that's the particularity in disciplinary cases at FIFA. In anti-doping, it's quite interesting. We know that doping works first with a disciplinary procedure, but you can also appeal cases, doping decisions, disciplinary doping decisions to the CAS. So this is the point from where a disciplinary decision from doping can go to arbitration procedure at CAS because you appeal. So when you appeal this decision, the disciplinary procedure changes to arbitration procedure, and now the rules from arbitration come along and play within the world of doping. So the anti-doping organization shall have the burden of establishing that an anti-doping rule violation has occurred. So as it's the same as before, like as a disciplinary infraction, WADA, as a doping organization, shall have the burden to must establish that an anti-doping rule was committed. This is quite simple because WADA, what they do is they test the athletes. So if you test an athlete and the athlete it's and the athlete goes positive for doping for any substance whatsoever, they are guilty of doping. Doesn't matter, no other circumstances are relevant. So if you have a positive test of doping, you committed an anti-doping infraction. So it's proven, fully proven. You don't need to do, you as WADA, you don't need to do more than that. So you already conquer the burden of proof. If you are a doping organization, it's quite easy. But this is not everything. If you are an athlete, if you're the suspect that committed anti-doping violation, you must produce the proof necessary to reduce or cancel a sanction. The athlete with burden to rebut the presumption or establish specific facts or circumstances. So if you are an athlete or if you're another person that committed a doping violation, despite WADA or other anti-doping organizations, they must prove easily the infraction. You as an athlete has the burden of proof to not to go again, probably to say, I didn't commit this infraction. But what is more important is to say, okay, the doping test, it's positive. I don't contest the result of that test. But what I will prove from now on is that probably there are specific circumstances around my case that will entitle for me to ask for a reduction of the sanction or to not be sanctioned at all. So the burden of proof for the athlete in this case, in doping cases, goes to rebut a presumption or establish specific facts that will help the athlete to not be sanctioned at all or to have the sanctions reduced. That's the burden of proof. I think it's, I know it was clear, like the simple rule is that if you raise a fact, you must prove it, but there are specific circumstances within sports law where this is principle, it's different, and the burden of proof switches from one party to another. It's not that different, but I will say that in practice, the burden of, I will come back to this, the burden of proof, it's not that simple. I mean, the slide is very nice. It seems really easy to understand. It's like, okay, I must prove that I must prove that probably there are circumstances around my case that will allow me to have my sanction reduced. But how do I prove that? We have here in the firm, we had a lot of cases where doping cases particularly, like we don't know how to prove something. Like, okay, we know that the athlete probably was positive because he consumed, I don't know, he consumed a contaminated product. Okay, the athlete says, hi, I didn't commit an anti-doping rule violation. Of course, he committed because his test was positive, but I didn't take the I don't know, the substance with the will to commit an anti-doping infraction. I didn't do it with the intention to commit an anti-doping infraction. I just had this contaminated product, and it was like really strange circumstances. And of course, I don't want to be sanctioned because I didn't have the intention to commit an infraction. I didn't want to enhance my performance, my sporting performance. So here the burden of proof goes to the athlete to say that there are specific circumstances around his case that will allow him to ask for a reduction of the sanction. But how do you do that? That's the main point. You have to do it, but it's really difficult to understand how to do it, because probably you can trust the athlete, you can trust his story. Probably if he's very confident with it, maybe you say, okay, I believe you. You didn't commit it. It was just a contaminated product. But how do you prove that he actually ate that food, that meat, whatever, and that meat was contaminated with a substance? So it goes further than that, further than the slide. It's quite difficult to really comply with the burden of proof. I think it's the most difficult part of my daily practice, to understand how to prove everything that I say. Of course, I know that I have to do it, but I need to put a lot of effort to go to the sources of the proof, to go to every single person involved, to speak different languages, to try to go to different jurisdictions to request stuff, to probably, and what usually happens is that you have a case now, but the facts took place 2 years ago, 2 years ago. 2 years ago, no one remembers anything. You will go to the seller of the meat, and you will tell him, okay, yes, this person bought the meat from you 2 years ago. Please, can you give me, the invoice of that purchase? The poor guy will tell you that they don't have it, or they don't remember that they did this purchase to this sale to this other person. So it's quite difficult to really comply with the burden of proof. That's what I can say for my practice, what I see the most challenging in CAS cases, to actually comply with the burden of proof. Now, the standard of proof. This is quite different. This doesn't go to the facts. Probably I will say that the burden of proof goes really to the facts of the case, that you have to prove with everything that you have, with all your resources that are quite expensive, whatever you are saying. But with the standard of proof is the level of what do you have to prove with what you bring as an evidence. So probably I have 5 evidences. I have a document, I have a witness, I have an expert. All of them will support my fact. All of them, in my point of view, will prove that something happened 2 years ago. But this is not enough. It's not enough that I believe that this is enough to convince the panel that this actually happened in the way that I am saying it. Usually, what do we have? It's some kind of rules or principles that we have to accomplish for the panel to understand that a fact did actually occur in the way that we are saying. I don't know if it makes sense. So that's the standard of proof. That's the level that I have to reach with all my proof, with all my evidence, to actually have a fact fully proved. I will say that doesn't matter. Fully proved. Fully. The panel must understand that this fact actually happened in the past. So, but this is not easy all the time, because the panel have different points of view. So what the sports regulations and what law did with this is that they create the standard of proof. So we have 3, but in sports law we have 3. Probably in other areas of law we have more. In criminal law, they are quite strict with this, so they have more levels. In civil law, it's quite simple, so they reduced the levels to two, I believe. I'm not an expert, so I don't know. But in sports law, we have at least three that are important. The first, the beyond reasonable doubt, comfortable satisfaction, and balance of probabilities. So beyond reasonable doubt is that the panel must be super comfortable with what I am saying. There is no space to doubt. If I prove that the player breached the contract, the panel must completely understand, they must completely be convinced, fully convinced, without any single doubt that the player breached the contract. They cannot doubt that this actually happened in the past. They have to be fully comfortable by saying, yes, it actually happened in the way that this party is stating in his submission, in the hearing, during the process. At level 2, we have comfortable satisfaction. This is a level not that severe, not that strong as beyond reasonable doubt. It's in the middle, comfortable satisfaction. They have to be quite, the word says by itself, quite comfortable. They must feel that they believe in our case, that they actually feel that this fact took place in the past. They don't have to be completely, they might have some doubts, but they must feel comfortable by preferring that this actually happened. And the balance of probabilities, it's the lower, I think it's the level 3. It's not that easy, but I believe that sports law works a lot with this in doping cases. So I think this one is the coolest, I believe. But it's not easy anyway. So you have to comply with some rules to prove the panel that your facts are proven in the way that are beyond the balance of probabilities. And what's balance of probabilities? It's the version of the facts are more likely than not to have occurred. Panel be satisfied that there is a 51% chance of a relevant scenario having had occurred. So this is not like the other levels of the standard of proof, like beyond reasonable doubt or comfortable satisfaction. This goes quite lower than that. Like in the first one, we said that the panel must have 0 doubts that something happens in the past. By the point 2, we have to state the panel must be comfortable by saying that, okay, this might have happened in the past. I feel that this happened. This actually happened. But in level 3, it's not that severe. So they are quite light if we compare it with the first 2. The versions of the facts are more likely than not, a 51% chance. You're in the middle, and you just need just 1% up for the panel to understand that a fact actually happened in the way that you are referring in your case. So it's not that severe. I think it's easy to prove that something was more likely than not to have occurred. So probably if I am in a doping case, I love doping, sorry. So I will refer all my examples to doping. And I think that doping works really well with this topic of evidence, because it's easy to go to CAS with a contractual dispute. It's super easy. You go with the contract and with your witnesses for the negotiation and for the execution of the contract. But with doping, it goes like far beyond that. And so you are an athlete that didn't take the substance with the intent or the will or the intention to commit a doping infraction. You did it by mistake. You did it because you were like in the house of someone that you knew, and this person had like a supplement that had a substance that you were, as an athlete, you were not able to consume, but you did it. But you didn't know that this product had this substance in its composition. So you must prove in this point, if you are in the balance of probabilities, you must prove that it's more likely than not that your test was positive, not due to the fact that you actually took a substance, a prohibited substance, with intention to commit a doping violation. You must prove that it's more likely than not that your test was positive due to the fact that you consume a potentially contaminated product in this friend's house. So the panel must just have a tiny doubt, they must be just secure a bit more than with a doubt that something happened. So I think this is better for the athletes, because if the athletes, they have to go with the standard of proof of the first level, will be actually important. Because in doping cases and in other kind of cases, it's quite difficult to go full with all the proof. You probably will never be able to reach that standard. So if an athlete is allowed to prove its case by the balance of probabilities, I think it's good for them, because they just have to prove that their story is more likely than not to have occurred. I don't know if that makes sense. I think it's quite complicated to understand, but I did my best. If you have any doubt about these points, I think with examples, it can be easily understood, like more easy. And I think about admissibility, I will say that usually this is easy. In terms of how a CAS panel ought to exercise its discretion, then it is bound to apply the rules contained in applicable sports regulations, if any. And if no, such rules exist, may admit evidence according to its discretion. In either case, the panel will always be bound by the relevant principles of procedural public policy. So probably I know that my case needs to be proven quite well, because the burden of proof is on me, and my standard of proof is quite high. So I know, okay, I need to present all the evidence that I have in my power and all the evidence that the other party has on his power, because I can ask the panel to request the other party to submit what is on my favor. But I know that I have to do it quite well, because my standard is high and the burden of proof is with me. So, but there's a point where you cannot present everything, because the panel will exercise its discretion to understand what is admissible or not. In terms of admissibility, the CAS code doesn't address anything. So for the CAS code, you can present everything. But the line that you cannot cross is the procedural public policy. So you cannot present before the CAS an evidence that was acquired on an illegal manner. You cannot present before the CAS a chat conversation that was taken without the consent of the other party. You cannot present to the CAS something that was taken without being regulated. You cannot present to CAS you cannot present to CAS testimonies of minors, because they are protected. So they will say, no, this testimony is not received. Or if you want me to admit this witness testimony from this minor, you must protect the minor before, like you must put the minor into, I don't know how to say it in English, to nominalization, like they must be anonymized to be able to testify as a witness during the case. So, but I will say that this is different in arbitration than compared to national courts. In national courts, if the ones that deal with national courts, probably a civil procedure, a criminal procedure, that are more strict with this, with admissibility of proofs. Probably they have quite strong rules, quite strong regulations that they don't allow everything. But CAS actually they admit quite everything. What they don't do is if you don't present your proof on time. That happens quite a lot. So the CAS code, I don't remember the article by now, but you must, at the moment you submit your appeal brief and your statement of claim, in ordinary procedures, both the big submissions in CAS procedures, you must offer all the proof that you have. You must present everything. You must present all the documents and write them as an exhibit, and you must state your witnesses and your experts at that time. If you don't do it at that time, you cannot do it before or after. There is no way to do it after, because CAS will say you are out of time. You had to do this before. So I think that's the main point where CAS actually works with admissibility, where they don't allow you to present the proof out of time. But of course, it is like national courts. If your proof was not disposable to you at the moment you were submitting your statement of your appeal brief or your statement of claim, you can actually refer to CAS saying, look, at the moment I was submitting this claim or this appeal brief, I didn't have access to this particular evidence that I think that it's important for the panel to take into consideration. So you must actually state the reasoning behind why you are late in presenting that evidence, and why the panel must understand that they must allow to admit this new evidence. I think it's like the same as national courts. It's not that different. And I think that's it. I think that's the main important points. I don't know if you want to discuss something further, if you want to go to the examples, if you want to go to my practice, if you want to go to any point that you want to discuss deeper than that.
Okay, Arianna, thank you very much for this clear presentation and interesting presentation. I know this is I mean, the procedure before the CAS is a specific area, and of course the evidence inside these procedures are a specialized topic. So thank you very much, Arianna. This is the moment to allow interaction with Arianna. I invite you to turn on your camera and microphone to ask any questions you might have.